Next time you saw her was today at this hearing on the computer
That is
screen. Is that right?
correct. That is
Okay.
correct.
Did you ever at any point see her or identify her to law enforcement prior to today?
I have not seen her. I have not seen her. I have not seen a picture of her. I haven't anything of her. There's never been a contact
Okay.
since that incident.
As you sit here today, this person you've identified as Wendy is sitting in jail orange, isn't she?
Yes,
Okay. And she's in a screen identified as Butler County Jail, correct?
I didn't know where she was at. I have never been told.
Well, is
So
the
I can't.
screen, ma'am, is the screen that she is on the computer screen, does it say Butler County Jail on it?
Yes, it does.
Now, the other person, this thin, petite person, since the day this happened, have you seen her at
Objection,
all?
Your Honor, relevance to this
No.
particular prelim.
Mr. Watts?
Wait, Ms. Zilke.
I think it goes to the reliability of the identifications in this case.
Wait,
Re-ask the question, Mr. Watts.
Go ahead.
Since the day this incident happened, have you seen the other person involved, this thin, petite girl?
No, I have not.
Okay. I want to make sure I'm clear. At no point did law enforcement approach you with any photographs of any people to ask you to identify anyone? Is that correct?
That is correct. Never have they done that. Ever.
They never brought a person by your house or your residence to see if you could identify them?
No, they did not.
And you've used the term Wendy here today to describe this person, okay? And I may have asked you this earlier. Where did you get that name, Wendy?
Objection, Your Honor, asked and answered.
Objection sustained.
Your Honor, I don't think I have any other questions today. Thank you.
Doris, is there any reason why we can't release Beverly Zielke from the meeting at this time?
No, Your Honor, thank you.
All right. Ms. Zielke,
Yes.
you can stay with this meeting if you want to, or you can leave it. But if you stay, I need you to go ahead and put yourself back on mute, okay?
I have to put it on mute.
Yes.
Wendy,
Yeah.
come here, honey.
Okay.
That I don't. Might have to call my.
That's fine. Very good. Very good. We'll move on. Ms. Norris, do you have additional witnesses to call?
Your Honor, just briefly, Detective Chandler.
All right. If you'd raise your right hand, please.
I did.
All right. Very well. Having sworn in the witness now, Ms. Norris, you may ask questions.
Please state your name and occupation for the record.
My name is Robbie Chandler. I'm a detective with the Butler County Sheriff's Office.
And how long have you been in law enforcement?
A little over 9 years.
Did you end up being the investigator affiant regarding Beverly Zielke case?
Yes, I was.
Where did you have contact with her at?
It was off of Indianola and I believe 120th. The exact address I don't recall.
Are there any hospitals or other medical facilities there in that area?
No.
Okay. And was this a gravel road?
Yes, it was an unpaved gravel road.
Okay. And were you able to find the scene where the incident happened? You were actually at somebody's house, but that's not where the incident happened, correct?
Correct. Yes, I was able to find the scene where it happened.
Approximately how far from where you had contact with Miss Zielke? Was that where the place of the incident?
Maybe 300 yards, 200 yards. It wasn't very far.
Were you able to identify Miss Zielke's car?
Yes, the 2024 Nissan.
Okay, and were you able to locate Miss Zielke's car at some point?
Yeah, on flock camera.
Approximately how much is that vehicle worth? And I don't need the specific.
I don't know if I have an exact value of it. I think it's more than $30,000.
Okay, more than $30,000.
Yes.
Okay, thank you. That'll be sufficient for our purposes at the moment. You were able to locate Miss Zielke's car, this Nissan?
Yes.
Were you able to, I guess, were you there when it was initially stopped, and who did that?
No. I was the on-call detective. I had gone home after the initial investigation, and I got called back out after midnight. WPD, Wichita Police Department, had made the stop and located the vehicle.
Okay. And did you then have information regarding who was driving this said vehicle?
Yes.
Who was that?
Miss
Objection, Your Honor, calls for
Wendy
hearsay.
Scott.
Your Honor, calls for
Ms. Norris?
hearsay.
Regarding the hearsay objection?
Your Honor, the officer may have gotten information from WPD, but had to identify and actually locate any persons that they were referring to. So, Your Honor, it does not go to the truth of the matter asserted. It goes to basically the process of his investigation.
With that limitation, Ms. Norris, the court will overrule the objection. You may continue.
And Mr. Detective Chandler?
Yes. Wichita Police Department had located the vehicle off, I believe, Shady Brook Lane and found Miss Wendy Scott as the driver. And I believe she had one other passenger, Mr. Alan Berry.
And were you able to talk to Miss Scott?
Yes.
And the person, where did you talk to Miss Scott at?
At the Wesley Medical Center.
Okay. Had there been an accident regarding the Nissan?
No.
Okay. So you ended up speaking to Miss Scott at Wesley Medical Center.
Correct.
And did she identify herself to you?
Yes.
And what did she identify herself, or how did she identify herself?
She identified herself as Wendy Scott. Trying to think how if you want to say it, but she just identified herself with name and date of birth.
Okay. And were you able to confirm that?
Yes.
Do you see the person that identified themselves as Wendy Scott on the screen today?
I do.
And please describe her for the court.
Black female. She's wearing an orange jumpsuit.
Your Honor, ask that the record reflect that the officer has identified the defendant, Wendy Scott.
Record again, so reflects.
And did Miss Scott talk to you about this case?
Yes, she did.
And did she do it under Miranda?
Yes, she did.
But even not under Miranda, did she do it voluntarily?
Yes.
And did she make admissions regarding what happened with Miss Zilke?
Yes.
So did she admit being in Miss Zilke's vehicle?
Objection, Your Honor, leading.
Objection is sustained. Let him tell the story here, Ms. Norris.
Just briefly, Detective, what did she tell you involving Miss Zilke?
She said she started off by saying it was all of her friend's fault. Said her friend was identified as a Tylisa. Said that it was Miss Friend's idea to give Zelke a ride into the county under disguise of being sick and taking her to the hospital. Once they got her out into the county, they would take her vehicle from her and her belongings.
Did you rely upon that name that she gave you when she was basically her, I guess, her co-defendant's name?
Yes, I did. And she said that those belongings were still of Miss Zelke's that they took were still in her possession. And with that information, I applied for a search warrant and executed a search warrant on Miss apartment in Wichita.
And did you find that Miss was or was not her co-defendant?
She was not. She had given me a statement that she had just gotten a ride from Miss Scott that night when I believe something happened to her car and she was chased by a dog. And this information was confirmed by Miss Colvin's employer.
Okay, so were you eventually able to identify the defendant, Miss Scott's co-defendant?
Yes.
And what's her name?
Elizabeth Rosa Rogers.
So based on your conversation, your interview with Miss Scott, the defendant, she basically admits that she was present and took Miss Zilke's car?
She said it was, I believe it was, may I refer to my notes real quick?
Sure.
Miss Scott admitted to the ordeal up until knowing how she came about having the car.
Say that. You kind of cut out a little bit. Miss Scott said what?
Miss Scott admitted to being with their co-defendant, Miss Rogers, up until the point where they were at Miss Selke's apartment. And the next thing she remembers is that she's in Miss Selke's car driving it around.
Okay. So she, okay. And was that when she's getting pulled over by Wichita PD?
Correct.
And is that the same day or basically the same 24-hour period?
Yes.
Thank you, Detective Chandler. I don't think I have any further questions, but Mr. Watts may have some follow-up.
Okay. Mr. Watts?
Thank you, Your Honor. Detective, I want to follow up on that last part.
Yes.
You spoke with Ms. Scott in a hospital, correct?
Correct.
Okay. Do you know why she was there?
No, I was never told why exactly she was there until later on. I was given that she had PCP in her urine.
Okay. She's there apparently for some sort of a drug treatment or something like that. Is that fair?
Yeah. Yes.
Okay. When was that? Was that the same day, the next day? When exactly was that?
That would have been when the police took her there. I think it was after midnight, so it would have been the 21st of July.
Okay. And this incident took place on the afternoon of the 20th, correct?
Correct.
Okay. So the next day.
Correct.
Okay. I guess here's what I'm trying to figure out. How did you come to go to Ms. Scott there in the hospital and inquire about this case?
She was taken there by Wichita Police Department after they stopped her vehicle in Shady Brook Lane and took her into custody.
Okay. And by her vehicle, are we talking about Ms. Zilke's vehicle?
Correct.
Okay. So WDP stopped the car, and she ended up going to the hospital.
Correct.
Okay. I presume, to your knowledge, then she's in the car, correct?
Yes.
All right. Now, if I understood your testimony at first, well, let me back up a little bit. What's her demeanor and condition as you're talking to her here in the hospital?
She would get loud. She was asleep. We had to wake her up a time or two. And then she would just start right back up where she led off at.
Okay.
She was aware. She knew who her name was. She knew where she was. She asked for us. She wanted to talk to us, law enforcement.
Well, the reason I asked that is I'm looking at your affidavit,
Yes.
and the affidavit tells that basically you learned that she was ready to talk, right?
Correct.
But when you got there, she was asleep and had to be woken up.
Correct.
Okay. As you're talking to her, did she fall back asleep again?
At one point during the conversation, yes.
Now, she spoke during this conversation with you in the hospital about essentially the plan to get control of this car. Is that correct?
Correct.
And that this other person that she identified as Colvin would essentially do the ruse to get her in the car and try to take her to the hospital.
Correct.
But you testified a moment ago that the next thing she knew, as she put it, she was in the car and being picked up by WPD. Is that right?
Correct.
She didn't provide any information of what happened in between?
Yes, she told us about going up into Miss Selke's apartment, that she was with Miss Colvin, and I think Miss Colvin at that point had stomach aches, and that was how they got her to go take her to the hospital, which was a way to get her out of the apartment. But Miss Scott never said anything about what happened after the apartment.
I think that's all I have at this time. Thank you.
And
Right.
actually, Your Honor, no further witnesses, but I do have some amendments to make on the record.
All right. Does the defense intend to present evidence at this hearing?
Not at this hearing, Your Honor. Thank you.
Very well. Your amendments that you're requesting, Ms. Norris?
Your Honor, state would be moving to amend count 1 to aggravated kidnapping, which is a level 1 person felony based on injury. And I would be moving to amend count 5 from misdemeanor theft to felony theft, a level 7 non-person felony based on the value of the Nissan plus the other items already listed in that count. And nothing further, Your Honor.
Any objection to the amendments, Mr. Watts?
No, Your Honor.
All right. Ms. Norris, your theory regarding the amendment on count 1, obviously, the bare bones pleading that you filed in this case doesn't help the court sort out exactly what your theory is. So now that you've upgraded from kidnapping to aggravated kidnapping, what is the evidence before this court that would suggest that the court should bind over and find probable cause as to either kidnapping or especially aggravated kidnapping?
Your Honor, aggravated kidnapping, taking or confining any person accomplished by force, threat, or deception. Deception because they basically got her to take them to, well, allegedly to take them to a hospital. And obviously they ended up being nowhere near a hospital. And then the aggravated portion of it would be when bodily harm is inflicted upon the person kidnapped. And the Ms. Zilke clearly stated she had bodily harm.
All right. And the evidence supporting a holding?
But basically she was in a vehicle and they basically, the theory would be that they took her and that she was basically confined in a vehicle. And it was all under deception, a ruse. Deception to get her to basically get away from her apartment so they could basically steal her car from her, but they had to isolate her out in the country. So basically, even though she's the one that's driving, they're the only reason she's going is because of them. So that would be state's theory.
All right. Taking her by deception with the intent to hold her to facilitate the commission of the later felony theft.
And the aggravated robbery.
Very well. The court will allow the amendment to count 1 to reflect a charge of aggravated kidnapping as requested, as well as the amendment to count 5, upgrading from misdemeanor theft to felony theft. Court finding that there is evidence in the record to support such amendment. Court further finds that based on the evidence presented, that the felony crime of aggravated kidnapping has been committed and that the defendant, Wendy Scott, committed it. Regarding count 2, the court does find that there's probable cause that the crime of mistreatment of a dependent elder person, a level 5 person felony, has been committed and that the defendant, Wendy Scott, committed it. Regarding count 3, the court does find that there's probable cause that the felony crime of criminal threat has been committed and that the defendant, Wendy Scott, committed it. Regarding count 4, the court does find that there's probable cause that the felony crime of aggravated robbery has been committed and that the defendant, Wendy Scott, committed it. Regarding count 5, the court does find that there's probable cause from this hearing that the crime of felony theft has been committed and that the defendant, Wendy Scott, committed it. Regarding count 6, the court does find probable cause that the felony crime of interference with law enforcement, a level 9 non-person felony, has been committed and that the defendant, Wendy Scott, has committed it. Therefore, the court binds the defendant over on all 6 counts as amended following a presentation of evidence. We will proceed to arraignment at this time. Mr. Watts, does your client desire the charging document to be read to her?
Your Honor, we discussed the charges. Would waive formal reading of same and are not guilty at this time. Ask the case be set for appropriate pretrial and jury trial settings.
Very well. Thank you, Mr. Watts. The court will set this case for both jury trial and pretrial conference settings.
And Your Honor, the defendant has her hand up. I'm not sure if she needs to address the court or her counsel.
Okay, well, we're going to do our scheduling first, then I'll address it.
Okay, it'll be February 25th for the jury trial date.
Court will establish pretrial conference as the next scheduled setting at this time for February 21, 2025, 9 o'clock a.m. That will be conducted by Zoom. The court will establish jury trial date currently set to begin 9 o'clock a.m. on February 25, 2025. That will be an in-person proceeding, Courtroom B, Butler County Judicial Center, El Dorado, Kansas, for all stages if it goes. Ms. Scott, I'll address you now.
Yes, sir. All I'm asking, my baby is dying. That's it. I wrote a letter to the courts and to my lawyer letting them know that she's dying. All I'm asking is for a fellow to speak with my baby. That's it. She might not make it to February. She might not make it 8 years from now, but my baby is dying. That's all I'm asking. She got Thursday cancer, sir. That's all I'm asking. Can I just see her?
Okay, who is your baby?
My daughter, Kanai Scott Collins. I wrote the court's input, her room number, what hospital she's in, and everything. I've been writing, asking. I just want to see my daughter. She got brain cancer. That's it. I've been begging and pleading. She's in Wesley. She's in Children's Mercy. She's in the PIC unit. You can call and verify it. I've been asking here just to call and talk to her at the nurse's station. I'm not even getting that. I don't even have money on my books because they won't let me work. I just want to see my baby. That's it. That's it. Just see my daughter. I'm asking you, Judge, whatever you want me to do. I'm not running none of that. You can put a monitor and everything. I just want to see my baby. She might not be there. She might not be able to see me 2 days from now. I'm just asking. Please, just hear me out.
Children's Mercy, where? Where's that at?
She's on Wesley Main, the Children's Mercy. She's on the PIC unit floor. She's in the pediatric ICU. You can verify
Okay,
it.
so I'm having difficulty because of your emotional speaking here, but I think you're talking about Wesley Medical Center in Wichita?
Yes, sir. She's on the PIC unit. She's in Children's Mercy. Dr. Her doctor.
Okay.
My baby is suffering. All I want to do is see her. That's it. Whatever y'all want to do. If she died in my arms, when she see me, then that's it. That's all I want to see is my baby. That's it, sir.
Does the state take a position on the request?
Please, please.
Your Honor, I don't. This is the first I've heard of it. I suppose without any verification, I would have concerns about that. I know her bond is currently set at 100,000 with GPS required, and that she's only to be in Butler or Sedgwick County. Obviously, Your Honor, I have concerns about her being out. She's got a lot of history out of the state of Iowa. She is presumptive. She's at least a C, maybe a B. It kind of depends on how some of her previous convictions shake out, but she's definitely a C. And based on these charges, she's presumptive prison.
I
So,
swear, I just want to see
certainly
my
have
baby.
concerns.
I just want to see. I wrote the courts and everything weeks ago. I just want to see her.
Right.
That's it.
The court will first of all make an observation. It seems to be kind of a disturbing tendency out of the women's cell at the Butler County Jail for them to write letters to this court asking for all kinds of things. Ms. Scott, apparently you are one of those that's bought into that. You're not supposed to be even trying to communicate in writing behind the prosecutor's back the way you've been doing.
I did. They told when I went to, I asked the person at the jail that's above in the jail.
And so when you attempt to communicate with the court, do you also send it to the prosecutor so that she knows what you're doing?
Okay.
I would suspect you don't.
I did, and they told me to write straight to the judge and to my lawyer.
All right. Well, all right. Regardless of how any attempted communication may have been sent to my office, Ms. Scott, the court is considering here that you are facing presumptive prison felonies. You've now been bound over on those.
I promise you, I'm not.
And I don't mean to be heartless or cruel. I don't know if what you're telling the court is legitimate or not.
My lawyer, I even gave my lawyer phone numbers and everything to verify. I gave him everything to verify.
You're a poor risk for a furlough, Ms. Scott. I don't want to be in a situation where you're released from the jail and we have to recapture you to get you back.
You won't.
There are implications to criminal behavior and you've been bound over on these felonies, the court has found probable cause that you committed these
Lord, can
crimes.
you please?
You haven't been convicted yet. The court clearly recognizes that. But again, there are implications to criminal behavior, Ms. Scott, and
Oh,
unfortunately,
I'm so sorry.
access to your family can be one of them. The
And
court is not going to
I'm the only
modify your
family
bond in
member
any way,
here.
and the court is not going to grant your furlough request.
Can
So
I
the
please
request
get
is
you my
denied.
bond?
The court has already considered and denied any bond relief. All right.
So if my daughter dies, I can't see her then either. I just want to see her. That's it.
All
That's
right.
all I was
Mr. Watts, anything further from your perspective at this time?
Not at this time, Your Honor. Thank you.
From the state's perspective, Ms. Norris?
Miss Norris, please.
No, Your Honor. Thank you.
All right. The Scott matter will currently be in recess.
The transcript captures an evidentiary preliminary hearing in the case involving defendant Wendy Scott, where the court evaluates whether sufficient probable cause exists to bind the case over for trial on multiple serious felony charges arising from a violent and deceptive incident involving an elderly victim. The proceedings begin with testimony from a civilian witness who encountered the victim, Beverly Zilk, shortly after the incident. He describes her as visibly injured, bleeding, and in a state of shock, recounting how she reported being deceived by two women who pretended to need medical help, coerced her into driving them, and ultimately forced her out of her own vehicle, before stealing it along with her belongings and her daughter's dog. The victim herself provides detailed and emotionally compelling testimony, explaining how one of the defendants feigned a medical emergency to manipulate her into offering transportation, after which the defendants redirected her onto a remote, rural road under false pretenses, threatened her with a gun, physically assaulted her, and forcibly removed her from the vehicle, causing significant injuries to her arm. Her testimony emphasizes both the use of deception and force, key elements that support the prosecution's theory of aggravated kidnapping and robbery. Importantly, the victim identifies Wendy Scott in court as one of the perpetrators, although the defense attempts to challenge the reliability of this identification by highlighting that the victim had not previously identified the defendant through formal law enforcement procedures such as photo lineups. Additional testimony from a detective further strengthens the prosecution's case by outlining the investigative process, including locating the stolen vehicle, apprehending the defendant, and obtaining statements from her. According to the detective, Scott admitted involvement in the scheme, describing a plan devised with an accomplice to lure the victim out, under the pretense of needing medical assistance, and then take her car and belongings. However, the defendant's account appears partially inconsistent, as she claims limited memory of events after leaving the victim's apartment, possibly due to drug use, which the defense later raises to question the reliability of her statements. Despite these challenges, the prosecution successfully argues for amendments to the charges, elevating the severity of the case by upgrading the kidnapping charge to aggravated kidnapping due to the bodily harm inflicted on the victim and increasing the theft charge based on the value of the stolen vehicle and items. The court accepts these amendments and finds probable cause on all counts, including aggravated kidnapping, mistreatment of a dependent elderly person, criminal threat, aggravated robbery, felony theft, and interference with law enforcement, thereby binding the defendant over for trial. The defense does not present evidence at this stage, focusing instead on cross-examination and procedural objections. The hearing concludes with the scheduling of a jury trial and pretrial proceedings, marking the transition from preliminary examination to formal prosecution. In a final emotional moment, the defendant personally addresses the court, pleading for temporary release to visit her critically ill daughter, who is reportedly suffering from brain cancer. However, the judge denies this request, citing the seriousness of the charges, the defendant's criminal history, and concerns about flight risk, while also expressing skepticism regarding the verification of her claims. Overall, the hearing reflects a strong prosecutorial case built on eyewitness testimony, victim identification, and partial admissions by the defendant, contrasted with a defense strategy aimed at undermining identification reliability and the credibility of statements. all within a procedural framework that emphasizes the court's role in determining whether sufficient evidence exists to proceed to trial rather than adjudicating guilt at this stage.